Uh, yeah, I'm a bit soft today. Well, not soft, but yesterday's slightly buzz stream was really, really good. Really good. For 3 hours, we went through the JLR case and especially the Magnolia timeline. I well, went to bed and woke up to uh, YouTube saying, yeah, this is now 18 plus due to nudity. And I was like, excuse me? And they showed a timeline about 2 hours and a few minutes in. And I went, okay, did somebody do something yesterday I did not remember? And no, that was the blurred body cam photo of when the cops went to see Magnolia at the hotel. No nudity. So, appealed. Because, yeah, this is stupid. And a few seconds later, we have reviewed your appeal and we're still determined. But now, with a new timestamp of 45 minutes and 14 seconds, I went to that timestamp and it's literally just the panelists on screen. And now I have exhausted my appeals, apparently. So I had to, well, whine about it a bit, but then eventually so downloaded it as a video, cut out those exact seconds, and posted that as a video over at YouTube. Now here on Rumble, everything's fine. You can watch it in its entirety. But those 2 seconds gone, and all of a sudden it was a-okay for YouTube to put it up as a video, even though they themselves claim, oh, this is more or less jam-packed with naked people, which it wasn't. And then somebody asked me, does that mean that YouTube allows nudity as long as you put an 18 plus sticker on it? I don't think so, but who knows? I'm not going to try it. So I'm a bit pissed off today. But also, it was a very successful stream. We spun the wheel of regrets a bunch of times, and so I'm fine. I'm fine. I promise you, I'm fine. Oh, what? Dave says that Logan says I need to visit Rhode Island. Rhode Island is quite a bit away from Indiana. Now, I did have plans to travel the East Coast this year up until the Rick Allen appeal is up for oral arguments in Indianapolis on September 21st. So, hence, Indiana. But I mean, eventually, where is Rhode Island? Isn't that like inside New York or something? No, there. It's south of Boston. Okay. It's upstate New York. Okay. It's only a 14-hour drive. Yeah, not going to do that. Yeah. No. I appreciate the suggestion, but I'm not going to drive 14 hours from Indiana to visit Rhode Island. Not this year, at least. If I'm going to Rhode Island, it will be at the time when I actually visit the East Coast, which might be maybe next year, maybe 2 years from now. Or I try to travel to the United States at least once a year, and I try to visit as many states as I possibly can before my body says no completely. But it doesn't. Not yet, at least. All right. So yeah, Rhode Island. Okay, I'll have it on my list. I will have it on my list. But what we are here for this specific subject. It is the government's response to defendant's notice of expert witness testimony and request for Daubert hearing. And this I hope, will put the Matthew Farwell defense on their face, so to speak. For you who don't know about the Sandra Birchmore case, Sandra Birchmore was a young girl who joined the joined the Explorers Youth Club in Stoughton, Massachusetts. And Matthew Farwell was an instructor there, and he saw her as, oh, I'm going to get that, as she stood there, 4 foot something, 13 years old. So he groomed her, and then he raped her for years. He handed her over to his twin brother. He handed her over to colleagues at the Stoughton Police Department. A few years down the line, Sandra Birchmore becomes pregnant. And Matthew Farwell, allegedly, to cover his ass and that he had been doing this to this child for years, ended her life. Now, in Stoughton, Massachusetts, is in the Norfolk DA's office jurisdiction, with DA Morrissey, who apparently thought to himself, no, I like PDF cops and corrupt cops and everything, so he is not going to press charges. But the feds did. The feds did. So this is in federal court. So that is roughly what the case is about. All right. Here is their reply to the defense not wanting this specific expert witness. The United States of America by Leah, U.S. Attorney, and Elizabeth Riley, Brian Fogarty, and Tori Cummings, Assistant U.S. State's Attorneys for the District of Massachusetts, responds to defendant Matthew Farwell's notice to introduce expert witness testimony of Dr. Thomas Andrew, and request that the court limit his testimony or, in the alternative, conduct a pre-trial Daubert hearing to determine the admissibility of certain areas of Dr. Andrew's proposed testimony. Footnote 1. Yeah, okay, so it's just C. Daubert versus Merrill Down Pharmacy from 1993. On June 4th, 2026, the defendant provided notice of his intent to introduce expert... Wait. Hold on here. Okay, wait a minute. This is... Okay, let's just read it. This is not the same expert. All right, let's just read it. On June 4th, 2026, the defendant provided notice of his intent to introduce expert testimony by Dr. Thomas Andrew. Dr. Andrews intends to testify to the facts and opinions set forth in a 9-page opinion letter that the defendants attached to his notice. Dr. Andrew has been a certified forensic pathologist since 1992, and the government is not challenging his qualification to testify generally. The government moves in limine to preclude Dr. Andrew from offering certain opinions for which he lacks sufficient experience. Okay, so this is not the expert who found out or concluded that Sandra Birchmore was a homicide, not the self-ending. So now that it's not the same expert. Okay, sorry folks. My bad. The government moves in limine to preclude Dr. Andrew from offering certain opinions for which he lacks sufficient expertise. First, Dr. Andrew should be precluded from testifying about anything related to Sandra Birchmore's mental health treatment, including the medication that she was prescribed. In these areas, Dr. Andrew, a forensic pathologist who has not treated living patients in over 35 years, offers opinions that exceeds his expertise. Yeah. Forensic pathologist is not a forensic psychiatrist or forensic psychologist. It's a different area. Yeah. Specifically, the government moves to preclude him from testifying to or, in the alternative, conduct a Daubert hearing to determine his qualifications and basis for the opinions he offers about the discretion and professional judgment of Birchmore's medical team. This includes his opinions that Birchmore's prescription for sertraline, without context, carried a black box warning for prone to self-ending. And two, that therapists are, quote, not uncommonly shocked at the self-ending of their patients. Wow. You're a forensic pathologist, Dr. Andrews. You're not a forensic psychiatrist, a forensic psychologist. I would say that's an overreach. And also, if the defense, Matthew Farwell's defense, if they can't find a forensic, if they could have used a forensic psychiatrist or forensic psychologist for this, they would have. But instead, they have this forensic pathologist for that purpose. That is really strange. Second, Dr. Andrew should be precluded from offering his opinion about non-medical, quote, elements of the case that favor self-ending, end quote, including a July 1st, 2017 journal entry that the government will seek to admit. Dr. Andrew exceeds his expertise as a forensic pathologist when he opines that this letter was a pro-self-ending note. What? He also exceeds his expertise when he summarizes now disproven, quote-unquote, self-ending threats on May 14th, 2020. Dr. Andrew lacks the expertise to testify regarding Birchmore's victimology, and this testimony would be cumulative of other defense experts who at least has minimal experience with the psychotherapy of self-ending. Finally, Dr. Andrew should be precluded from opining about the discretion and professional judgment of Dr. Capo Martinez, the medical examiner in this case. Specifically, Dr. Andrew should be precluded from opining that Dr. Capo Martinez was persuaded by the USAO and FBI to amend the Birchmore death certificate. Oh, fuck. That's in quote. So Dr. Andrew claims that Dr. Capo Martinez was coerced into changing his testimony. That's an extraordinary claim that demands extraordinary evidence, not just an opinion. Dr. Andrews' conclusion is unsupported and beyond the scope of his professional expertise. The government conferred with Farwell's counsel to seek agreement to limit Dr. Andrews' testimony to topics that his expertise supports. The parties could not come to an agreement. Dr. Andrews should not be able to testify about the psychology of self-ending generally, or Ms. Birchmore's alleged prone to self-ending. He also should not be permitted to testify about medication that he does not prescribe, its impact on living patients, or any warnings that it may or may not have carried over 20 years ago, when he was also not treating living patients. Nor should he be permitted to testify regarding his opinions about the relationship between therapists and their patients, never having worked as one, and not having consulted with any in this case. Yeah, this is starting to sound like a hired gun. Oh, you want me to say this? Sure, I'll say that. Accordingly, the government respectfully requests that the court preclude Dr. Andrews' testimony on these topics, or in the alternative to conduct a hearing on the Dobert to resolve the foregoing issues before permitting Dr. Andrews to testify at trial. Background. On February 4th, 2021, at approximately 11 a.m., Birchmore was found deceased by members of the Canton Police Department. Yeah, Sandra Birchmore was living in Canton when Matthew Farwell went there from Stoughton and allegedly ended her life. That is why in this case you will find an overlap between the Ken Reid case and the Sandra Birchmore case, because it had a bunch of the same investigators. Skillet Pan asks if I'm covering the Tupac case. I am not. I'm not. But AV to the seventh power does. So I recommend that you, if you want to see that case, go over to her channel. She was found seated, reclined backward under a closet doorknob. A duffel bag strap was tied around her neck and affixed tightly to the closet doorknob above her head. Members of the Mass State Police responded and photographed the crime scene. On February 5th, 2021, Dr. Capo Martinez conducted an autopsy on Birchmore. At the time of autopsy, she was relying on a death notification report, which contained information from state and local law enforcement noting that the death was a self-ending. Yeah, local cops, friends with Farwell. Yeah. It was a self-ending. The fuckers who found her didn't even search the place. When her parents came in after the crime scene was released, they found her ripped off necklace and pendant under the bed, among other things. Other things that was out of place. That's how thorough the local cops were. And this is the year before they botched or intentionally botched the Ken Reid case. And the common denominator is the actual killer is a cop. Or law enforcement. Or family with law enforcement. At the time, no members of law enforcement attended the autopsy. So it was just an opinion from the people at the scene. On February 9th, 2021, Dr. Capo Martinez was again notified by the state police that they were treating the case as a self-ending. On May 1st, 2021, Dr. Capo Martinez reached out to state police investigator to determine if there were any investigative updates in the case, and she was told that there were none. Yeah. For the local cops, their investigation was looking at her and more or less nothing else. That's about it. On May 6, 2021, Dr. Capo Martinez issued a death certificate ruling that Birchmore's cause of death was asphyxia by hanging and that the manner of death was a self-ending. Dr. Capo Martinez noted a furrow mark around Birchmore's neck, petechial hemorrhages of the bulbar, and palpebral conduct, whatever it is, skin of the face and larynx, hemorrhage of the left sternothyroid muscle, and a fracture of the right hyoid bone. Need some messes. Nick, I hope you have Grant on your channel at some point. He's connecting so many points between this case and the Reid case and much more. Well, I'm warming up to the guy, but my first encounter of Grant Smith Ellis, was the Depp V. Heard case, and he didn't leave a good impression. But I'm warming up to him. Maybe at some point, to the point where I can have a discussion with him. Oh, and thank you so much for the Jules. Shannon Cooper, 2 Jules. Thank you. That is so nice of you. Nice of you. Thank you so much. Yeah, if you're watching this via mobile phone, you have the option of sending over Jules. I'm not entirely sure what 2 joules are, what's the monetary worth of it, but I do know it is that is 2 joules I didn't have 5 minutes ago. So thank you so much. Thank you. Let's see, where were we? Yeah. She also noted and photographed a 2.3 by 2 centimeter dry red-brown abrasion on Birchmore's right upper chest. Dr. Capo Martinez will testify that the physical finding with which Birchmore presented were either more prevalent in homicidal strangulations than in self-ending hangings, or at least equally present in the two. Despite this, Dr. Capo Martinez originally ruled the manner of death as self-ending based on the investigative updates, or lack thereof, from investigators. On June 18th, 2024, Dr. Michael Baden, that is the doctor that the defense wants excluded. One of the leading experts. Ignore the first few minutes of this stream, because I actually thought this was their reply to the defense attempt to exclude Dr. Baden. It wasn't. But it's an update. On June 18th, 2024, Dr. Michael Baden, a forensic pathologist retained by the estate of Sandra Birchmore, issued a report in which he opined that the physical injuries found on Birchmore were commonly found in homicidal manual and ligature strangulation, but not in self-ending hangings. Dr. Baden served as the director of medico-legal investigations at the New York State Police for over 25 years, and prior to that as chief medical examiner for the city of New York. Dr. Baden opined that in his 50 years of experience, a fractured hyoid bone occurs rarely, if at all, in self-ending hangings. He also noted that the extensive degree to which Birchmore's hair was tangled in the ligature was inconsistent with his experience seeing self-ending hangings. Dr. Baden concluded that Birchmore died from homicidal strangulation. On the day that Dr. Baden's report became public, the defendant authored a goodbye letter to a close family friend asking him to take care for his children. Yeah. The same day Dr. Baden's report became public, that it was a homicide, not self-ending, Matthew Farwell authored a goodbye letter to a close family friend asking him to take care for his children. Now, Farwell expected him to be arrested by Massachusetts State Police, and that they would open a case and charge him on a state level. But no, even he miscalculated the absolute level of corruption in DA Morrissey's staff and DA Morrissey himself. Had he known that the entirety of the Norfolk County DA's office not only support corruption, they support PDF cops, PDF rapist cops, PDF rapist murderer cops. And I'm sure that many others were surprised as well. But that is the situation. Michael Morrissey supports PDF rapist murderous cops. You draw your own conclusion as to why he does that. But Matthew Farwell authored a goodbye letter asking him to take care of for his children. In August 2024, Dr. William Schmock, a leading expert in the field of asphyxia-related deaths with over 40 years of experience in the forensic evaluation of injuries, issued a report in which he opined that a seated hanging in which so little of Birchmore's body weight was suspended would not have resulted in a fractured hyoid bone. He opined that Birchmore's gender and age made it even more unlikely that such a passive method would have resulted in this injury. He indicated that in his 40 years of experience, he has never seen a fractured hyoid bone in a seated young person. Dr. Schmock also noted that the injury photographed by the medical examiner on Birchmore's right upper chest is a patterned imprint, the consequence of blunt force trauma caused by a lobster clasp on the duffel bag strap. The clasp that caused these injuries was found nowhere near the injury site when Birchmore was recovered, meaning that she could not have died in the position in which she was ultimately found. Yeah, I know. We have to reword what we actually say because YouTube believes that people are going to faint and run for the streets, clasping their pearls, if we actually say the words of the crime that is committed. Even though my channel on YouTube says this is not for children. No, only the news are allowed to say those words. Dr. Schmock also noted that Birchmore had abrasions on the inferior and lateral aspects of her nose, and opined that these types of injuries are commonly seen in cases where a victim moves their nose back and forth against something in an attempt to breathe. He opined that, based on the totality of the circumstances, Birchmore's cause of death was asphyxia, and her manner of death was homicide. In August 2024, members of the prosecution team and FBI met with Dr. Capo Martinez to ensure that there was no information that the team had not considered before charging the defendant with murder. There was not. Dr. Capo Martinez requested to review a voluminous discovery that had not been generated or made available to her prior to her May 2021 ruling. In April 2026, when the government met with Dr. Capo Martinez for the second time to prepare her expert notice due May 1st, 2026, Dr. Capo Martinez informed the government that, based on her review of the material, she was no longer on the opinion memorialized in her May 2021 report. Yeah. The state police hid things from Dr. Capo Martinez. Hid things. And now when she reviewed materials that was hidden from her, she had a change of mind. In April 2026, Dr. Capo Martinez amended the death certificate, ruling Birchmore's cause of death to be asphyxia and manner of death to be undetermined. So not all the way to homicide, but she could no longer in good conscience say it was self-ending. Yeah, the mass state hiding stuff, unheard of. On June 4th, 2026, Farwell noticed Dr. Andrew Thomas, a board-certified forensic pathologist with 20 years of experience at the New Hampshire Medical Examiner's Office. Dr. Andrew Thomas concludes that the, quote, final resting place could exert an inward-directed force sufficient to produce the fracture observed at autopsy. What way? To my recollection, the fracture was okay. He does not cite any studies, medical literature, or any example of cases that he has worked on in the past 20 years that form the basis of this opinion. Specifically, he does not provide any support for his conclusion that a 23-year-old female sitting, almost reclined, under a closet door handle and tilting her head to the left would have caused a fracture to the right superior horn of a hyoid bone. Next, he concludes that Birchmore had vaguely patterned, apparently perimortem abrasions on the right side of the back, which may represent abrasions caused by thermal hypoxic seizure activity against the closet door. He again provides no support for the basis of this conclusion. With respect to the fracture to Birchmore's right greater horn of a hyoid bone and hemorrhage on the left sternothyroid muscle, Dr. Andrews states, of particular note is the absence of any description of hemorrhage associated with the fracture at autopsy. While he is correct that the hemorrhage is not noted in the autopsy report, he ignores photographs of the hyoid bone itself, taken by the FBI at the request of the government's expert, which clearly depicts a hemorrhage at the fracture site. How did the FBI take a picture of the hyoid bone itself? Because Birchmore was buried shortly after the autopsy. How could they, unless parts of Sandra Birchmore was saved somehow? And also, does this mean the FBI was involved investigating the Norfolk County and the Massachusetts State Police already in 2021? Huh. Now that's interesting. Huh. Interesting. Photographs of the hyoid bone itself, taken by the FBI at the request of the government's expert, which clearly depict a hemorrhage at the fracture site. Yes, somehow this suggests that the FBI had access to Sandra Birchmore's body. Yeah. Let's go on. Dr. Andrew also suggests that the post-mortem drying artifact on the nose has been overinterpreted as smothering. He neither confirms nor denies that there are visible abrasions on her nose, and has noticed no opinion of the source of the marks on Birchmore's nose. Oh wow, thank you for the 1,000 euros from But Ask the Animals. Thank you, thank you, thank you. That is so, so nice. Thank you, thank you, thank you. Again, I have really no idea how much 1 euro is, let alone 1,000 euros. But thank you so much. It's definitely 1,000 euros I did not have 5 minutes ago. So thank you, thank you, thank you, thank you. And folks, monetary support of my channel is always appreciated, never necessary. Because in today's economic climate, I don't expect it. The economy is what it is. And I do get a little bit of ad revenue from Replay Crew. As you may have noticed, I don't have midstream ads. So If you can, please do. If you're struggling, don't. Do not. If you're struggling, I actively forbid you from supporting my channel monetarily. Leave a like, subscribe, watch the entire show, watch a bunch of videos, and I'm fine. All right, let's continue. Dr. Andrews agrees with Dr. Smock's conclusion that the injury to Birchmore's right side of her chest is a visible patterned perimortem abrasion. He further agrees that the petechial hemorrhage observed on Birchmore are consistent with asphyxia and not necessarily helpful to definitely differentiate self-ending hanging versus homicidal strangulation. Dr. Andrews' ultimate conclusion is that based only on the crime scene and autopsy, he cannot conclude that the manner of death was homicidal asphyxia to the exclusion of self-ending hanging. Or in other words, based on the medical evidence alone, self-ending is not impossible. He opines that Birchmore's cause of death is hanging, not asphyxia, and her manner of death is undetermined. It is at this point in his opinion notice that Dr. Andrew begins to opine about issues beyond the scope of his expertise. Dr. Andrew writes, of additional note is the fact that Miss Birchmore had been prescribed sertraline, a selective serotonin uptake inhibitor, SSRI, 12 days prior to her death. As far back as 2004, it was noticed there appeared to be a subset of those prescribed SSRIs who were at increased risk of self-ending early in treatment or with change in its dosage. In January of 2005, the FDA required a so-called black box warning on all SSRIs and antidepressants, highlighting the increased risk of self-ending thoughts and behaviors in children, adolescents, and young adults up to 24 during the initial stages of the treatment. Dr. Andrew provides no support for where it was noted over 20 years ago that this medication caused an increased risk of self-ending and cites no study to support this proposition. Sorry. Oh. Not only has he not disclosed the basis for his statement, but the defense has not noticed any training or expertise or experience that would render him qualified to offer an opinion to the jury that sertraline is, what potential dosages are, what it is used to treat, or what the risk factors are. Dr. Andrew does not and has not for 35 years treating living patients. He has never worked as a psychiatrist or mental health provider. As such, his attempt to second-guess Birchmore's prescribing doctor's decision cannot be reliable testimony that the jury should be permitted to hear under Federal Rules of Evidence 702. Yeah, I agree, because if the defense is going to challenge this, they need a psychiatrist. And thank you to mispronounced name. I'm a bit behind, but wonder if they exhumed her with her family's permission to check for things like the hyoid. I don't think Sandra Birchmore was. No? At least there is no official report. And she was cremated. So it's not much to exhume. Pardon my French. But it's a valid question. It is absolutely a valid question. And thank you so much. Thank you. Yeah, that thing is weird. That the FBI or that somebody took a photo of that specific hyoid bone. It's strange. Dr. Andrews should also be precluded from sharing his opinion, which he admits is a personal and not a professional opinion about therapists and their relationship with their patients. Specifically, Dr. Andrew writes, finally, in my personal experience of 20 years as a chief medical examiner in New Hampshire, therapists are not uncommonly shocked at self-ending of their patients, but self-ending is simply not reliable, predictable in patients with depression, particularly when there is a confluence of acute stressors. Yeah, he may have, but that is anecdotal evidence. And anecdotal evidence are usually not permitted even from experts. Now, professional experience, yes. But this is not part of his professional experience because this is not his expertise. Dr. Andrew has never worked as a therapist or psychiatrist and has not treated living patients for decades. He did not engage with any of Birchmore's mental health providers, and his personal opinion generally as to the relationships between therapists and their patients is an impermissible overreach. Relatedly, Dr. Andrew should not be permitted to offer his opinion as to non-medical evidence that he alleged favor self-ending. Specifically, he writes that Birchmore had a documented history of self-ending behaviors. Among her writings are a note dated 7/1/2017 that can be considered a proto-self-ending note and a pros and cons analysis regarding self-ending dated 6/30/2017. Self-ending threats prompted the involvement of the Stoughton Police Department on 5/14/2020 with involuntary evaluation at Good Samaritan Hospital. There is nothing in Dr. Andrews' 11-page CV, his 9-page opinion letter, nor Farwell's notice of Andrews' testimony that suggests that Dr. Andrews is any more qualified than an average person to test about whether certain journal entries or police reports demonstrates prone to self-ending. Yeah, and remember, Sandra Birchmore was groomed, raped, and ultimately murdered, allegedly, by Matthew Farwell, a police officer. She was groomed and raped by other officers in the Stoughton Police Department. These are the same cops who tried to have her committed. So yeah, why was she all of a sudden? I would suggest that this is just evidence that the entirety of the Stoughton Police Department knew and just wanted to keep her silent and wanted to make her have the appearance of a crazy person. Because in 2020, she was 22 years old. She has been the victim of the Stoughton Police Department officers for, I believe, 7 or 8 years. Of course, they wanted to make her out to be a crazy person. While he may discuss what he reviewed, he cannot describe them in a manner in which he attempts to his notice and characterize such testimony as an expert opinion. Dr. Andrew does not and has not treated living patients in decades. Offering an opinion from Dr. Andrew on Ms. Birchmore's alleged prone to self-ending is also cumulative of another expert that they have noticed. So they already have a psychologist or therapist or psychiatrist. Well, then they don't need another one. But at the same time, I have to say, the state often do this. When they have expert with overlapping expertise. You have the Clancy case going on now, and the state is just putting on person after person after person after person to testify about the same thing. And apparently when the state does it, oh, it's okay. When the defense does it, no, we can't have that. So hence my, But in this case, with Dr. Andrew, he's not a psychiatrist or psychotherapist or psychologist. So he really can't testify to that. And every time the state does the same, just accumulating witnesses saying the same thing, when you see me covering trials when that happens, I object to it vehemently because it's not fucking necessary. Yeah, it's a clown show. Thank you. Hi, Mark. Did it? Hi, Mark. So yeah, I'm consistent with that. No cumulative presentation of evidence, regardless if it's the defense or the prosecution. Sadly, the state or the court system is rarely of the same opinion. Let's continue. Finally, Dr. Andrew should also be precluded from offering his personal conclusion about a meeting between law enforcement and the medical examiner that he did not attend. Specifically, he opines that the medical examiner's amendment of Ms. Birchmore's death certificate as the result of persuasion by the FBI or the USAO, this patently false and dismissive opinion should give the court pause about the reliability and unbiased nature of the remainder of Dr. Andrews' opinions. While the defendant is free to cross-examine Dr. Capo Martinez herself about the amendment to Ms. Birchmore's not birth certificate but death certificate, Dr. Andrew lacks first-hand knowledge to render an opinion that should be offered to the jury. While Dr. Andrews' experience in some areas is certainly sufficient to permit him to render opinions that could assist the jury, he is not a psychologist, psychiatrist, or even a doctor who has treated live patients for decades. His expert opinion ladder overreaches, and the defense has declined at this point to limit his testimony to comport with Federal Rules of Evidence 702. Argument. The court should conduct a Daubert hearing to determine whether to exercise its gatekeeping function and exclude Dr. Andrew as unqualified and or limit his testimony. Okay, oh, was there okay, this he opines that the medical examiner's amendment was persuasion by the FBI or USAO. And here is the footnote. Curiously, Dr. Andrew does not comment on a pre-trial meeting that the defense held with Dr. Capo Martinez in the spring of 2026. Yeah. I assume that was a pre-trial meeting with Dr. Capo Martinez where they tried to make a change of mind again, allegedly. Rule 702 governs the admissibility of expert testimony and provides that a proposed expert witness must be sufficiently qualified to assist the trier of fact, and that his or her expert testimony must be relevant to the task at hand and rests on reliable basis. And they quote a few cases. The rule states in part that, quote, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto if the testimony is based upon sufficient facts or data. The testimony is the product of reliable principles and methods, and the witness has reliably applied the principle and methods to the facts of the case. The court has an important gatekeeping role by screening proffered expert testimony for both reliability and relevance. Expert testimony must be relevant not only to the sense that all evidence must be relevant, but also in the incremental sense that the expert proposed opinion, if admitted, likely would assist the trier of fact to understand or determine a fact in issue. Quoting a lot of the cases here. It is Farwell's burden as the proponent of the expert testimony to demonstrate its admissibility. A. Dr. Andrew has failed to disclose information establishing that he is qualified to opine about Birchmore's victimology. The court should conduct a hearing to determine whether Dr. Andrew is qualified as an expert by knowledge, skill, expertise, experience, training, or education to opine about Birchmore's victimology, which entails an evaluation of her mental health and her alleged history of self-ending behaviors. The First Circuit has held that an expert must do more than disclose his or her mastery of a broad umbrella of topics without demonstrating a focused expertise in the particular subject of his or her proposed testimony. In Tetjokine case, the court held that the district court properly excluded expert testimony by Sergei Khrushchev, the son of former Soviet Premier Nikita Khrushchev, concluding that while Mr. Khrushchev may have possessed some expertise regarding the world affairs and national security issues, that expertise did not qualify him to testify regarding family law and adoption customs in the former Soviet Union, which was the issue relevant to the proffered defense. The First Circuit specifically rejected the notion that Mr. Khrushchev's purely anecdotal knowledge would satisfy the requirements of Rule 702. Dr. Andrews' expert report does not identify any education, training, or practical experience that indicates that he has the requisite knowledge to assist the trier of facts in their understanding of Birchmore's mental health or her inclination to being at risk of committing self-ending. While Dr. Andrews' resume and expert report describe experience and expertise regarding anatomical pathology and forensic pathology, they say nothing about his familiarity or expertise in psychology or psychiatric medicine. Therefore, until Dr. Andrew discloses a basis for his opinion regarding that material that he does not have any educational or professional expertise in, the court should exclude his testimony regarding Birchmore's mental health. Dr. Andrew cannot opine about the professional judgment of Dr. Capo Martinez or Birchmore's medical team because he is not qualified to do so. Based on Dr. Andrews' report, the court should also preclude him from testifying regarding the professional judgment of Dr. Capo Martinez and the basis for an amended ruling. In forming an opinion, an expert must base his or her testimony on sufficient data and tether that data to the use of reliable principles and methods. Furthermore, an analysis of Rule 702b requires an evaluation of the expert's conduct. Here, Dr. Andrew has not disclosed any basis to support his accusation that Dr. Capo Martinez was persuaded by the USAO and FBI to amend the Birchmore death certificate. Additionally, Dr. Andrews has failed to cite any data to support his opinion about the pregnancy-related anxiety medication that Birchmore's prescribed. It must be reiterated that Dr. Andrew is not a psychiatrist and does not treat living patients. He is not qualified to testify about psychiatric medications. Furthermore, he is not an obstetrician and is not qualified to testify about the interplay of psychiatric medications and pregnancy. Finally, he never treated Sandra Birchmore. A forensic pathologist who has never worked as a psychiatrist and is not treating living patients for 35 years simply lacks the expertise necessary to render an opinion about anxiety medication provided to a pregnant person who he never treated. Her OBGYN would have access to Sandra's history. Should. And we don't know the dosage of this medication. It is not mentioned the dosage here. Well, and 12 days before, it's to adjust to an SSRI is up to a month, with adjustments up and down depending on how the patient is reacting to it. But 12 days is definitely enough for the initial evaluation. And to my recollection, everybody around Sandra who knew her said she was ecstatic of being a mother. Let's continue. Dr. Andrew also made a brief but sweeping generalization of his personal, not professional or trained experience with therapists, and stated that he's shocked that Birchmore's therapist experience when she learned of her sudden death was not uncommon among the other therapists that he has personally encountered throughout his career. Again, Dr. Andrew has not reviewed the communication that Birchmore had with a therapist, nor spoke with a therapist or even reviewed prior interviews with her to come to his overly broad conclusion, and relies on no professional or educational experience to opine such an imprudent generalization. Accordingly, Dr. Andrew has failed to disclose the basis to opine about the discretion and efficiency of Birchmore's medical team. Ooh. And thank you so much to Filters, who sent a sunshine Yule. Thank you so much for 200 Yules. Thank you. Again, very, very nice. Always appreciated, never necessary. But oh, that is also nice of you. And I still don't know the monetary worth of the jewels, but I do know it is jewels I didn't have 5 minutes ago. So I'm eternally grateful. Eternally grateful. Let's continue. For the foregoing reasons, the government respectfully requests that the court conduct a Daubert hearing to resolve the government's objection to the proposed expert testimony of Dr. Thomas A. Andrew. Respectfully submitted, Leah B. Foley, U.S. Attorney. And her team. And certificate of service and everything. Yeah, I mean, this was not the reply I was expecting at the beginning of this. I expected it to be the government's reply to the defense objecting to Dr. Baden. But no, it wasn't. So sorry if I misled you a bit in the beginning. But yeah, it seems like this defense witness have opined about things he really has no experience or training in. And that is unsettling. That is unsettling. Because that, in my opinion, puts his entire opinion, even as a forensic pathologist, that makes me question that as well. Had he only went in there as a forensic pathologist and questioning the findings of homicide, go right ahead. It's a battle of the experts. But the moment he stepped out of his zone, out of his field of expertise to opine about other things, that actually makes me question his opinion in the whole matter. It is unnerving. It is unsettling when these things happen, especially in cases like this. Especially in cases like this. So we are still waiting for the government's reply to the defense wanting to exclude Dr. Baden. Dr. Baden is the forensic expert, a renowned expert who has worked on many, many cases, prominent cases throughout his career. His finding, they want to exclude because they claim that he doesn't have the expertise and that has no basis for his opinion. We are still waiting for that reply. And I can't wait to hear it. I cannot wait to hear it. Oh, and thank you to mispronounced name. She sent a trophy cake for 1,000 joules. Thank you, thank you. That is, again, I'm extremely thankful. Extremely thankful for all of that. Again, don't know the worth of these joules, but I am eternally grateful. And thank you to a werewolf for your 10 joules. And Honey 2800 sent a jammin for 200 joules. Again, don't know the monetary worth of it, but I'm eternally grateful. And this latest 3 is 1210 joules. And that is 1210 joules I did not have 5 minutes ago. Again, eternally, eternally thankful. But that is what I had for you on this Saturday. Now, I might return later today to talk about things that has been going on in Canton, Massachusetts. But it is 3 p.m. where I am. I'm meeting up with Miss Viking in an hour. And I might be out for the night. Folks, thank you. Thank you so much. And from me and Mr. Jingles, who is down there and not in here, thank you. You all have a good one, and I will see you in the next stream or video. Thank you so much. Bye-bye.